unius est exclusio alterius. Now we deal with the fact why that is not applicable. We refer to the matter of the case of Zenzile.
Is this in response to the reference to alcohol in particular?
Yes.
In the regulations?
In the Act.
In the Act, yes.
In the
Sorry,
Act,
in
yes.
the Act, yes.
Yes. They say because there's a specific reference to alcohol and there's no reference to cigarettes, therefore there's no authority to restrict or prohibit the sale of tobacco and tobacco products. And we, in paragraph 19, we deal with the reasons why that cannot be the case. In paragraph 21, we submit that the purpose of the general power under section 27(2)(n) is that the legislature could not possibly contemplate every sort of disaster that may occur and attempt to confer specific powers relevant to all disasters. That's why 27, there's a mistake there, it should not be 28, it should be 27(2)(n) empowers the making of regulations regarding, and I quote, other steps that may be necessary. We'll come back to the wording here of may be necessary to prevent an escalation of the disaster or to alleviate, contain, and minimize the effects of the disaster. The legislature was not able to predict with absolute certainty what steps may be necessary in a given situation, and so elected to leave this within the discretion of the minister. And we submit that on that score, the interpretation by Fita is unduly narrow and runs contrary to the purposes of the Act. If in fact Fita is correct, we submit that the minister could only ever limit the sale of one class of goods, namely alcohol, regardless of the disaster and regardless of what was necessary in the circumstances. We submit that that's an untenable proposition. We then deal, my lord, my ladies, with the question of necessity. Fita argues that the impugned regulations are not necessary as required by section to which I've referred in section 27(3). This requires, firstly, determining what necessary means, and secondly, assessing whether the regulations meet the required standard. And this we have addressed in our main heads, and I'm not going to repeat. This is from paragraphs 116 to 137 of the main heads. And also 120 to 131 of our main heads. We submit that the test of absolutely necessary cannot apply where the minister makes regulations to deal with a pandemic situation in terms of section 27(2). Instead, we submit that the regulations must be necessary in the sense that they are reasonably required in order to meet the objectives of section 27(2)(n) and 27(3).
Do you have authority for that proposition, that we should understand necessary within the sense of reasonably required?
Lord, we deal with that in the main heads. If we can go to the main heads page, paragraphs from paragraph 116.
You can give me the page number, the case line's page number, I'll find it.
013, it's 013 and page 58.
58.
Yes,
Okay.
yes. Where we state the following, that at 120, the question is what the applicable test is. When will a regulation be considered necessary within the meaning of these provisions? There is, to the best of our knowledge, as yet no reported case concerning the meaning of the phrase may be necessary in 27(2)(n) or the word necessary in section 27(3). Later on, Lord, my ladies, will show that there is a constitutional court decision which interprets a different section of the regulations. We dealt with this in our original heads and in our supplementary heads, and the learned friend has referred to that decision in his argument. We submit that the term necessary has been interpreted in other legislation. It has been held to mean, on the one hand, indispensable or absolutely necessary, or on the other hand, reasonably necessary. Much depends, we submit, on the context. We deal with the case of Pongo, in which the Constitutional Court considered the meaning of necessary in section 84(1) of the Constitution. But section 84(1) gives the President the powers necessary to fulfill the functions according to him. The Constitutional Court held that the necessary powers conferred on the President by this section were only those powers reasonably necessary to properly fulfill the functions endowed by section 84(2) of the Constitution. Then we deal with other cases. In Jobu, we deal with a Namibian case presided over by the former Chief Justice Mohammed. This is paragraph 122.4. In the Namibian case of Atchison, the court interpreted the meaning of necessary in a provision of the Criminal Procedure Act, which provided that a court before which criminal proceedings are pending may from time to time during such proceedings, if the court deems it necessary or expedient, adjourn the proceedings. The court held that the word necessary meant reasonably necessary in the circumstances of a particular case. This is obviously to be contrasted with expedient, which it held to mean what is advantageous, proper, or suitable to the case, judicious. And we also refer to the case of Mantiginga interpreting the Ciskei Constitutional Decree of 1990, where the court held that a restriction of a fundamental right applies only insofar as it is strictly necessary for protecting the values enumerated in the restrictions clause. I pause here, Lord and ladies, to mention that in the PEGO decision referred to in our heads and by our learned friends, the constitutional right that was being protected in that matter was the rights conferred by section 26(3) of the Constitution. And as we have submitted, in this case we are not dealing with the protection of any constitutional rights. In fact, we do mention that case in the next paragraph, that in PECO, the Constitutional Court stated that a municipality's power used a different provision of the Act, 55(2)(d), may be exercised only insofar as it is strictly necessary for the purposes set out in 55(3). That means that the powers concerned may not be used for purposes other than evacuation. As my learned friend has correctly pointed out, the section in 55(2)(d) of the Disaster Management Act dealt with evacuation. And what the municipality did in that case was not to evacuate in that sense, but it was to evict people and demolish their houses. That was obviously yes. The section in the Act relied upon was the evacuation to temporary shelters of all or part of the population from the disaster-stricken or threatened area if such action is necessary for the preservation of life. That is the section that was being interpreted in PECO. And what the municipality did in that case was not to evacuate the people, but actually to evict them and demolish their structures. So obviously in that case, the action of the municipality were unlawful. Well, we submit that the courts did not, in fact, squarely consider or deal with the meaning of the word necessary. And we submit it was not actually necessary to deal with it. Or as we say, it was not strictly necessary to deal with it. And to that extent, we say that that expression, strictly necessary, might actually be regarded as obiter in that case. The statement it makes is made in answering the question whether the municipality's powers was exercised for the authorized purpose, not whether the exercise of that power was necessary. And we continue dealing with that. Now back to our supplementary heads at 02011. What will bear with me? Our attention is being drawn to what follows in our original heads, 01362, paragraph 124, where we say we submit that necessary in sections 27(2)(n) and 27(3) means reasonably necessary rather than absolute necessity or indispensability. And we say so for a number of reasons. First one, that a proper interpretation of the legislation gives effect to the purpose of the Act and broader legislative context, and prefers a sensible meaning over one that leads to insensible or unbusinesslike results or undermines the apparent purpose of the Act, and we refer to the Ndumeni municipality case by the Constitutional Court. Further, legislation must be interpreted so as to promote the spirit, purpose, and objects of the Bill of Rights. An interpretation that falls within constitutional bounds must be preferred to one that does not. The scheme of the Act is to provide mechanisms for effective disaster management. In Section 26(1) places primary responsibility for coordinating and managing national disasters in the hands of the national executive. In terms of 26(2), the national executive is given broad discretion to deal with a national disaster in accordance with existing legislation as augmented by the regulations or directions made in accordance with Regulation 27(2). Regulations 27(2) in turn confers a broad discretion on the designated minister to make regulations, issue directions, or authorize the issue of directions concerning the matters listed there. And we submit that the powers are broad and they are aimed at ensuring effective and efficient disaster management in situations where decisions must be taken quickly, particularly, Lord and ladies, particularly, as I said at the beginning of my argument, in this pandemic situation, in order to protect the public. They need to be broad enough to cover a broad range of disasters and to permit the relevant persons to take steps necessary to adapt to and deal with that disaster. It is in light of that the term necessary must be interpreted. In a situation of disaster management, the designated minister is required to formulate regulations to contain the effects of that disaster and to protect the public. Whereas here, the disaster is a pandemic of a new and voracious disease, the minister is tasked with making regulations to contain the effects of that disease and ensuring that it does not overwhelm our public health system. And we say the obligation is also augmented by the government's obligation in terms of Section 7, subsection 2 of the Constitution to protect, promote, and fulfill the rights in the Bill of Rights, including the right to life and the right of access to healthcare services. The state is also required in terms of Section 27(2) of the Constitution to make reasonable measures to achieve the progressive realization of the right of access to healthcare services. But more importantly, the state has a duty to take steps to prevent the spread of the disease and to reduce the burden on the health system so as to ensure that those who need these services can have access to them. This duty is particularly acute in the pandemic situation in which we currently find ourselves. We conclude by saying that the minister is therefore constitutionally required to take decisions concerning lockdown regulations with this duty at the forefront of her mind. These constitutional obligations also form part of the relevant context within which the term necessary must be interpreted. Now, we further say, Lord, the ladies, that it cannot be required that the designated minister show proof of necessity in the sense of absolute certainty that unless the measure in question is imposed, the health system will definitely collapse. If the minister were to wait for such definitive proof, she would almost certainly be in breach of her constitutional obligation to promote and protect the rights to life and health care, as she would have failed to be sufficiently proactive in preventing the risk to the public from materializing. She would also have failed to take reasonable measures to realize the right of access to healthcare services. to read the provisions in this manner would thus render them unconstitutional, and we submit that this must be avoided. Lord, Lady, the rest of our submissions are in our heads, and yes. Okay. Except for just moving on to 132, 01368. As to what this means, some guidance we submit may be drawn from the meaning of reasonably necessary in law concerning implied power. this mistakes effective. According to the opinions of those more qualified than Fita or lawyers, the evidence is clear that smokers are at heightened risk of developing a more severe form of COVID-19. And this we address in my main brief, paragraph 59. Fita says it's common cause that the evidence is inconclusive. We submit that. Well, the minister quite frankly and fairly indicated that science in this area is still developing. There's no admission on the papers that the evidence that smokers are at heightened risk of developing a more severe form of COVID-19 is inconclusive. Rather, what is said is that emerging medical literature indicates that smokers are more likely to develop a more severe form of COVID-19. And that the view the minister has taken of the import of the relevant literature is shared not only by members of the South African medical community and experts in the relevant fields, and we mentioned who those experts are. That possible mechanisms linking smoke to the outcome of COVID-19 were under study. A recent review suggested smokers are vulnerable to respiratory infection because of impaired immunity. Smoking can upregulate angiosensine-converting enzyme, ACE2 receptor, the known receptor for the severe acute respiratory syndrome, SARS coronavirus, and possibly SARS-CoV-2 causing COVID-19. The results of the updated meta-analysis further confirm the impact of smoking on the severity of COVID-19. We also refer to 008195, that is documented by the World Health Organization. Smoking and COVID-19 scientific brief, that the harms of tobacco use are well established. Lord, I thought His Lordship wanted me to counter. Well, the submission, as my Lord pleases, then it's